You doing all right now?
Yeah.
Okay, great. Well, I appreciate the opportunity to be with you all. Wish I could be there in person. But as I'm sure Ori has explained to you, the AWE conference was just awesome, unprecedented in the number of participants and the level of discussion that was had. And one of the panels that I moderated in particular was called Law, IP, and Ethics. So what I'm going to do is kind of cover the highlights of what we talked about in that conference and in that panel, and even some of the discussion that's happened even since that panel. So although the IP, or intellectual property aspect of legality was called out in the title of that panel because it's such an important aspect of the legal issues surrounding this new technology, it's certainly not the only one. In fact, what's unique about augmented reality in particular in the technological field is that what makes augmented reality augmented, what makes it different from virtual reality, for example, is that it's tethered to the physical reality. We'll explain this to people on the street. They ask us what's the difference between Oculus Rift and augmented reality. Well, Oculus is an example of virtual reality, something that happens in its own completely defined space. Whereas AR, augmented reality, augments the things that are around us, makes greater the physical reality that's around us. So that brings with it some interesting legal issues that come with that tying to the physical world. And I've written and speculated a lot about physical injury issues. What happens when people have to go to a physical place to interact with this digital data, and thus run the risk of actually hurting themselves or hurting somebody else in the process of going to find this digital data. That's a question that doesn't come up with virtual reality or virtually any other type of technological issue. It comes up solely and uniquely with augmented reality because it requires that interaction with the physical world. And in the past year, we've actually seen some episodes of this happening. So for example, a few months ago, a Reddit user posted his experiences actually getting arrested while playing the game Ingress. I don't know how many of you are familiar with the Google game Ingress. Yep, okay, good, a decent number of you. So for those who aren't, it's a reality-based AR game. It's really the first successful, massively multiplayer augmented reality game on the market. It requires users to actually go to various physical locations throughout their locality to capture certain devices and turn them against the enemy side. There's two opposing forces, and you capture these devices and turn them either your color or the enemy's color. And it requires collaboration on a massive scale. You can see a real-time global map that shows you the status of the game. It's really an engrossing premise, and the people that I've talked to who actually play the game are very much into it, as you'll see with any other game with a cult following. But we actually had the first episode of someone actually get arrested while playing the game. That's largely because when Google set up the game, they had to pick locations for these digital objects to be, and they use a map. They use public building, public location. So they happen to locate one right in front of a police station. And this user stands in front of the police station using his his mobile device to try and capture this digital object, and it takes a while. And that caught the attention of the police, who's wondering why they're standing in front of the police station, pointing their phone at it for a long period of time. So he actually got detained for several hours while he had to explain the situation to the cops. This is the one that's gotten the most notoriety because he happened to be a Reddit user and posted it online. But I've since talked to local players here in the Detroit area who have had not that type of experience, but similar experiences. For example, again with the public locations, they pick public landmarks to locate these digital devices. So one of them happened to be located in the driveway to an emergency room of a hospital. And you couldn't get close enough to this device, this augmented content, to turn that device to your team without basically standing in the driveway of this ER. Now that didn't end up hurting anybody, but it certainly could have. What happened is they got in touch with Google the umbrella that they work under, and said, hey, this needs to be moved. So they ended up, Google actually responded and moved that location away from that driveway. But where we see different episodes, like I've talked to people who have been pulled over by the police while playing this game because they, in order to capture digital location, they have to drive around it so many times. People play this game while they're driving, and that was suspicious behavior and caused them to get pulled over. So there are a number of these incidents already cropping up. We're going to see more of them, and that's the sort of thing that is a legal issue unique to the augmented world. Now, of course, intellectual property issues are front and center of any emerging technology, and AR is no different. One topic that we spent quite a while discussing, with good reason, at the AWE conference was that of patent protection. Because this is one of a few areas where we've actually seen real litigation filed within the past year. So almost a year ago now, there's a company in Texas called Lennon Image Technologies, which filed the first batch of patent infringement lawsuits, specific to AR, specific to companies using augmented reality in the retail space. And their argument was, we own this patent that covers the technology that you're using, and you're infringing on our patent by doing what you're doing. Now, the actual claims in these lawsuits are a bit of a stretch. The patent at issue was actually issued back in the early 2000s. It deals with a concept of interacting digitally with a customer who's located in a physical brick and mortar store. And there are other details to this patent that are a little bit dissimilar to what people do with AR. But the argument is, anyway, that it's conceptually identical to what different companies are doing with webcam-based retail applications for AR. So the companies that were sued for this behavior were those that are out there on the internet doing virtual try-on websites. So Takari, for example, the jewelry maker, would let you hold your hand up to the webcam and see one of their rings on your finger. You can move your hand, and the ring would appear as if it was really there. Balaji, Bulgari, I don't know. I'm not a fancy guy, so I don't know these names off the top of my head. But one of the high-end watchmakers, anyway, did the same thing with wearing your watch. You can move it around, and it looked as if you were wearing this watch. And one that gained the most attention was Mattel had the Barbie Dream Closet, where you could actually stand in front of this webcam and see yourself wearing Barbie clothes, for those who are into that sort of thing. Each one of these retailers got sued for using this technology. Same mechanism, different application, different product at issue, with the same mechanism being used. And Lennon said that this infringed their technology. Now, Lennon is what you call a patent troll, meaning that they are a non-practicing entity, or they are a company that owns a patent right but doesn't actually do anything with it in commerce. They own this patent solely for the purpose of suing other people for infringement. And they also followed a time-tested patent troll strategy, which is to not sue the company that actually makes the technology, which in this case included such industry leaders as Zugara and Total Immersion, but to sue the retail clients of those companies who are just using it in a one-off application. So, for example, Zugara supplied the technology to Mattel for this Barbie Dream Closet, but Lennon didn't sue Zugara because they know that Zugara has a vested interest in defending this technology and beating this patent lawsuit. Instead, they sued Mattel, who only intended to use this once and doesn't think it's valuable enough to put a lot of money into defending this lawsuit, so they pay whatever they need to pay to make that lawsuit go away. And then they take the money from those settlements and it funds the next round of lawsuits. So we saw the first batch of these filed last July.